respond. We'll hold on the file till you get back out, but looks like he may not be here.
I think there is I couldn't tell if the name John Michael tried to respond.
Oh, John Michael there, maybe?
That it was on mute. So
Sir, if you could unmute for me there. Are you there?
I am.
Are you John Hayes?
I am the living man known as John Michael. I am not the surety for the corporate trust of John Michael.
Hold on,
Hayes.
hold on. I'm just asking just straightforward. Are you John Hayes?
I am not the corporation of the John.
Sir, okay, all right, we'll deal with it. We'll deal with it after. Mr. Jamal, we'll put you back with Ms. Powell and then we'll come back out.
okay, thank you.
Okay, sir. Do your second one, your Citibank versus John Hayes. This is file 2425, and I've got another gentleman here, John Michael, who apparently has filed paperwork.
Yes.
Mr. John Michael, you've got semicolon Hayes, respondent. First of all, are you an attorney?
I am not.
Okay. So do you have, you're alleging in, I guess, all these documents that you're somehow a representative for John Hayes. Is that right?
That is correct, sir.
So how are you, or it says beneficiary. Do you have some paperwork giving you some authority to act for John Hayes today?
The UCC 1 that was filed.
But no, is there an order, court order? I understand the rules and the statutes and the laws, but do you have anything that says, listen, you've got authority?
I have nothing other than the process of the United States corporation that started the trust in my name.
Who started the trust in your name?
The Corporation of the United States of America after its bankruptcy.
Oh, you went through a bankruptcy?
No, the United States of America, the corporation did.
Oh, I got you. But you have nothing that says you can represent John Hayes then?
I'm not acting as surety for John Hayes, that is for sure.
All right. So we've got a motion to dismiss. I don't have an attorney that's filed a motion to dismiss. I guess, Mr. Jamal, let's hear that first, I guess.
Your Honor, I guess my understanding, you said motion to dismiss. Is that for plaintiff's motion for summary judgment you're referencing? Well,
you've got your summary disposition motion that's out, but he's got also, it looks like his motion to dismiss, defendant's motion to dismiss. That's one I think is probably easier to deal with first.
Okay.
I don't even know what it, quite frankly, it is, but you did respond to it, it looks like. Plaintiff's response to defense motion to dismiss. Anything you want to tell me on that one, I guess?
Nothing further, but for the fact that, based on my understanding of the court rules, everything was filed as required by the law. No actual documentation is required with notice pleading state, of which Michigan is. Notice is provided since we have provided detailed account documentation supporting our claim. So I think his motion to dismiss related to failure to state a claim and lack of subject matter jurisdiction should both be denied.
Okay. And Mr. however you want to refer to yourself, John Michael?
John Michael, yes, sir.
Okay. What did you want to tell me about your motion?
Well, I asked all of the parties involved for validations, and I sent a statement of facts, and none of which were responded to. So that would be acquiescence to the truth of my statements, which should stand in truth and commerce. I asked for a contract and demonstration where there was adequate consideration giving, and did not receive any of that. It's my understanding that the consumer credit transaction or the application was taken by the Citibank and Best Buy to securitize the collateral to the Department of Treasury for their funds. They were paid, and now they're asking for me to pay in addition to that. I did not realize any of this was true until recently. And now if I'm continuing to be required to make payment in any form of negotiable instruments, they are, in my opinion, are being unjustly enriched. They have never given me a contract with a signature. They've given me valid verification by bills and statements, but never anything that would demonstrate that they ever had anything at risk or that they lost anything. Therefore, without a contract, there is no standing, there's no claim to bring remedy to.
You find there's been significant number of documents that have been filed, one being the motion to dismiss this matter. It's signed John Michael, Hayes beneficiary. I've got no indication that John Hayes, whose pleading this is filed against, is in fact here. I've got no attorney representing John Hayes. I've got some allegations that John
Sir,
Michael, hold on, sir, it's my turn. Sir, it's my turn. John Michael is somehow representing John Hayes. That's one problematic point with the motions that were filed. It's got a notice of special appearance, but I can't have a special appearance without some authority from John Michael. I did get a chance to review nonetheless all the documentations with regard to the motion to dismiss. I reviewed plaintiff's response to that defense motion to dismiss. I do find there are a significant amount of documents that have been attached regarding this account that alleged to have not been paid. It's a credit card account of some sort. All of the addresses match up to the same John Hayes at the same address, 5141 Flagler Street, Flint, Michigan, 48532. Statements were going to that address. I see the card or the account was used on that occasions throughout the documents that have been supplied. Also find that there were some payments made on that account as well. Therefore, based upon all of the evidence at this point, based upon this motion to dismiss, that motion is denied. And now we're on plaintiff's motion for summary disposition based on MCR 2.116. Is it a C9, C10? I guess I gotta look. C9, C10 motion. Mr. Jamal, this is your motion at this point. What, on this motion, did you receive a response to the motion for summary disposition?
I did receive a reply from the defendant. That was somewhat recently. I'm not sure if the court has that in the file.
Okay, I got it.
It's titled the reply. Let's have it opened here.
You should have it since it was filed at the courthouse.
What's it titled?
It's titled response to defendant's motion to
Oh,
dismiss.
I got that one.
Okay, that's the only one I see.
Okay. Mr. John Michael, is that the only response to the motion for summary disposition?
You asking me?
Yes.
Yes.
Okay. All right. I've got that.
That was the last response because I have not received anything more from them.
Okay. All right. So I've got that in my hand as well. Mr. Jamal, you can proceed with your motion.
Yeah, so the motion is primarily based on 2.116C10. Included with our motion for summary, we've provided detailed account statements that breaks out the usage of the account from a zero balance to the balance we're seeking in our complaint. We show not only usage, but also payment made towards the account. Those statements were sent to the address we currently, I believe, service was made to defendant at. Given those facts, we are seeking a motion for summary be granted in the amount as requested. And I would just indicate too, defendant has referenced seeking a wedding signature, additional contract terms, etc. However, usage of an account constitutes agreement for liability on that account. These statements specifically indicate that this account was sent and used without objection by defendant, and therefore liability should exist.
Okay. And the amount, it looks like, just on the, I don't want the court cost, but it looks like the damages for the card, the count itself is 2,349.65. Is that the right amount?
That is correct, yes.
Yeah. All right.
And that should be supported by the last statement we have included in our packet. Also has a balance of $2,349.65.
So let's see that here. Oh, way in the back here.
The payment due date on that statement is February 17, 2025.
No, thank you, Jamal. I was just looking for the last, here it is. Yeah, I'm sorry, February 17, 2025. That's the last
Correct.
one I'm seeing. Yeah. Okay, Mr. John Michael, any response?
Well, actually, kind of my paperwork should stand on its own. There was billing statements are self-generated and lack foundation and are inadmissible as live testimony and of custodian with a personal and no one of personal knowledge under MRE 8036. Prior payments do not establish a contract liability. My my realization of the fact that the Citibank, Best Buy, and or the law firm have provided any adequate compensation to complete the contract, and nor did they express the fact that they were changing my standing from the creditor because it was my creditworthiness that created the substance for the loan. They were paid. That was basically conversion from me from the creditor to the debtor. Under trust law, it converts my standing from the beneficiary to the trustee. And I affirm that there is no standing that they have to file a claim against the living man. And if you're refusing to...
Mr. Michael, from what I hear, though, you're acknowledging that this is your account.
I am not acknowledging that it is my account.
Well, you just said that they used your credit standing to form the basis of the contract originally.
Yes, that is true.
So how are you not?
Therefore, if it was my financing the credibility that funded this loan, how do I owe them any money?
Sure, I quite understand, Mr. Jamal.
I'm not hearing you.
The only response I would have, Your Honor, is he does reference admissibility. I think Michigan law is pretty clear that when it comes to a motion for summary, documentation is admissible to the extent that it would be admissible at a trial with proper foundation being laid. Foundation does not need to be laid at the motion for summary stage. There is no need for testimony or additional authentication. So the statements are properly before the court at a motion stage.
Okay, I'm just going to take a brief recess off the matter. I'm going to review the statements that have been supplied. Nope, that's it. We're done. Nope, I'm going to make a decision. Hold on. I'll be right back on. Sir, you told me that already. I'm going to take a brief recess. I'm going to review all the pleadings in its entirety, and I'll come right back on. Okay, we can come back on the record with Citibank versus John Hayes. I've had a chance to review all the pleadings and documents that have been provided by both sides. This matter. This is a motion brought in part by MCR 2.116C10. This motion may be granted where there is no genuine issue of material fact and which would entitle the movement to a judgment as a matter of law. In determining the factual support for this claim, I have reviewed all of the pleadings, affidavits, any depositions, admissions, and other documentary evidence that's been provided today. It should be noted that the non-movement party, that being John Hayes in this matter, does not rest merely on allegations or denial of the pleadings, but also must demonstrate by documentary evidence that there is a genuine issue for trial. I do find after significantly going through all of the documents that have been provided to me today, the consistency of the statements that went out, starting with a a new account through Citibank on this account, and this account was, let's see, where is it? Card ending in 8271, John Hayes. You find that this card was used over a significant period of time. There were also payments made over a period of time. The address was sent, all of these documents were sent to, these statements were sent to John Hayes at 5141 Flagler Street, Flint, Michigan, 48532. Do find it's consistent with what's been complained of, the amount owing. The final statement that has been complained of today, February 17th, 2025, shows a balance owing of $2,349.65. Find based upon all the documents, all the pleadings, there's no genuine issue material fact. Grant motion for summary disposition to Citibank for damages $2,349.65 plus court costs that are being requested. Mr. Jamal, I thought I saw somewhere in here.
There was a proposed judgment submitted with the motion.
Okay. Just gotta find it.
Everything's still in order. It's typically page 7 or 8.
If it's still in order, does that mean I may have torn it apart? Is that what you're telling me?
Potentially.
I'll find it here. It's probably the last page. I think I saw it somewhere in here. And military affidavit. I got everything here.
It's typically right after the military F.
Yeah. See, for some reason, we get all these statements that are attached too. As usually, I can find it right off the bat, and it's this one's that I can.
If needed, I can email.
Do you have the figures in front of the court costs?
I do.
What do you have?
Filing fee of $75.
Okay.
Motion fee of $20.
Okay.
Service fee of $58.68.
68.
Total is $153.68. Add that to the damages amount referenced, and total balance is $2,503.33.
Okay. Oh, here, and when I found it right at the end. There it is. I do have the proposed judgment showing the amount I asked for damages originally, the total on February 17th, $2,349.65, plus the court cost is just recited for a total of $2,503.33. Judgment for plaintiff in that amount based on summary disposition. Answer 2.11610. I'll sign that proposed judgment and send both of you a copy. Okay?
Thank you all.
All right. Good luck to both of you.
I object, Your Honor.
Okay.
I'd like to make a comment that you're making a judgment based on no contract. All the 6 requirements of a contract were not met. I came to the realization that there was no consideration and no risk and not full disclosure. And you're still going to judge against that without a contract?
I'm not taking questions, sir. You can put your statement on. Is there anything else?
I let my paperwork stand again, and I will have to file for an appeal under Article 10 of the Constitution. This controversy is greater than $25. I will be filing in the Court of Appeal.
Leave it at that, and I've signed the summary disposition judgment I just ordered, and we're all set. Good luck to both of you. Okay, bye.
Fraud.